It is time for us to check in with Chris Dimakos. He's our CJAD 800 legal contributor. And Chris, a very timely story as it turns out. I think people probably heard by now, a bit of an eye-opener, that over the past month, Quebec police arrested over 800 people for either driving drunk or being high. That's in 1 month. That was the story until the next story overtook it, which is a man, one of those people who was stopped by police for allegedly driving drunk, went to court, and it turns out he got off. And the reason why is kind of interesting, but more importantly than why is what this means for other people who may decide to go the same route. Now, this concerned a breathalyzer test that was administered. So can you pick it up from there and explain what happened?
Right. So anytime you get pulled over, there are two times where tests are usually administered. First is roadside, right? And you have this little apparatus that basically tells the officer whether you pass, you are in a gray zone, or you're way over the limit. It's a very quick test, and that entitles them to bring you to the police station, which at that point there's a much more specific test that gives a reading on your blood alcohol content level. It's that second test that was discussed in this judgment, and basically what it says, and we've had many people challenge results of these tests, and what the law has evolved to suggest that there's a presumption that says that the operator, the person conducting the test, and with the machine, it's valid, it works, it's legit, and the results are credible. Now, what this defendant did was he was able to show that the police officer in question wasn't up to speed with his certifications, and there are certain requirements you have when you're a police officer to take the necessary trainings and to be up to date with the usage of the machine every 90 days. Well, they were able to show that this police officer was on break for 6 months at a time or 4 months at a time, and not to mention the police station where he was operating from had very little handle on administering all of the different officers and their credentials and keeping them up to date with such. So what the judge says was it was a really lax situation in terms of ensuring certification and making sure everyone is up to date with their credentials, and that's why they basically said we're gonna acquit this defendant just because the evidence in question is not strong enough. There's a doubt there as to whether or not the results can be relied on. So what does it mean for everyone? It just means that if you are in a situation where you get pulled over and you go through the whole process of being arrested and then being called to court for trial, your lawyers have to go through all of these different possible defenses that are there, ranging from when you got pulled over, what you were asked, what the machine, who took the results for the machine, what was the police officer in questions, what's their credentials like, what have they been doing for the past year at the station. So they go through the whole thing. There's many different defenses.
Yeah, sorry, I'm going to stop you just for 1 second. Yeah. My first question would have been, how would you even know? Like, what kind of work would you have to do as this man's attorney to be able to find out about this one specific police officer, the fact that he'd been on leave? I mean, that seems like way more than you ordinarily would do in trying to plead a case like this.
Actually, that's a very good question. So what you get handed to you is a full disclosure of the evidence, and as a defendant, you're entitled to have these things. You can send subpoenas, you can make requests, you can have all of these things. And what has happened with the hundreds of years that we've had now with the criminal justice system is we've had precedents where, because courts have ruled on these matters, defendants can request them. So what's going to happen here? I mean, you raise a great point. What does this mean for all the other defendants who got arrested? Does this mean they can rely on this judgment? Well, it means that they might want to take a second look at who the officer was that conducted the test and take a look at their history over the last year, where they were, whether they're up to date with their certifications, and whether they can bring this forward as a possible defense. So, again, it's just a question of doing your due diligence, and it's not a new defense. It's nothing that hasn't been tried before. It's just that in this case here, the judge basically said, it was very lax in terms of keeping everything up to date and administering certification. So this defendant was fortunate enough to have that as an option as a defense, and it worked.
I wonder, when we talk about what this means, I mentioned right off the top, 800 people stopped in 1 month, right, by Quebec police. Does this become the standard now for defense? I mean, if this guy got off and he's done the work, his lawyer did the work, does that, you think, mean that a lot of these cases will just get thrown out, or is each one handled on a different individual basis?
Each one is handled on a different basis, and I would suggest that this situation that arose, I can't speak for the all the different police stations and how they run, but I would say this is not prevalent. It may be, maybe there has been a tremendous amount of budget cuts and monitoring these things has dwindled in terms of their diligence. But I would suggest that it's not so common to have this situation come up. But the point here, what people should take from this is you have to go through all the possible scenarios, and it's not about getting somebody who's guilty off the hook. It's as important for the police to to conduct themselves with their obligations just as it is for a defendant to do theirs. So this is more of a question of the police not doing what's required by them to ensure that these judgments stick, more so than what the defendant did or did not do.
Okay, and we don't have a lot of time, but I did want to talk on this other topic that you have in your sheet today, which is this idea of people living in condos, and this is something I'd not heard of, now being forced basically to sell their condos because they can't get along with their condo board or other people in the building. Is this starting to happen more and more?
More and more. First of all, the condo situation is a real tough one, just because they've gotten so small and so expensive per foot that most people now are not considering it, especially young families. But that being said, amongst those who are condo owners, if you have one owner that is completely not getting along, verbally assaulting, physically assaulting, being a real problem within the communal environment, there have been more and more, and successfully so, motions to have them completely removed from the communal environment and forcing them to sell their condo. So, I know we don't have much time, but you'd be surprised how prevalent this is becoming. So if you are looking at buying a condo, you have to do your due diligence again. Look at the condo meetings, see where they are with their budgets, see what's wrong with the condo. It's not just a question about what it looks like from the outside, how spacious it is. You want to look at the details about how this condo association is being run. Is there a lot of conflict? Are they having meetings about issues, defects? All this stuff is so important before you enter into a purchase contract for a condo.
So what we'll do, we'll kind of focus on that, I guess, next time we chat. Chris, thank you so much. Appreciate it.
Thanks, Aaron.